of history, constitution of police officers are with two permeating police surveillance, which they seem to think is a great danger to free people and escape some criminals punishment. Do you agree or disagree? Why? What evidence can you offer to support your position? What lessons from history do the forefathers draw upon writing the Fourth Amendment and the Fifth Amendment? Do the protections of the Fourth Amendment need to be expanded beyond the police to include protections against commercial enterprises and government agencies? Why or why not, and how you may be able to do it?
In his fourth essay, Federal Farmer Force stated, "There are other essential rights, which we have justly understood to be the rights of freemen, as freedom from hasty and unreasonable search warrants, warrants not founded on oath, and not issued with due caution for searching and seizing men's papers, property, and persons." We agree with Justice Jackson's statement that the founders designed the Constitution to first protect individuals from too much government surveillance, placing criminals' due process rights at risk.
Citizens believe privacy is still more important than due process. With new technology prospering, issues continue to arise since citizens and the government are confused about the boundaries separating individual rights and the common good. The Supreme Court is currently reviewing Worry v. U.S. to establish precedent for these technological disputes. This case questions the constitutionality of police reviewing a person's call log after they have been arrested. In contrast, the Fifth Amendment has not been altered to correspond with the 21st century.
The right to privacy and its importance to a free society has always been understood, even though it was not written down until the English Bill of Rights. The founders realized that before the English Bill of Rights, the government was infringing on people's privacy rights, such as their excessive taxation and encroachment on their property. As lamented in the text of the English Bill of Rights, the pretended power of suspending the laws or the execution of laws by regal authority without consent of Parliament is illegal.
This declaration gave the forefathers a significant perspective on natural rights of citizens, and principles such as these helped set up the provisions for the Fifth Amendment. In the 1630s, Charles I used the Star Chamber to abuse the power of the courts to suppress dissent. Founders wanted to avoid this type of court from surfacing in the new country, learning from history that in order to have a fair trial, the due process and grand jury rights of citizens must be preserved.
The Spanish Inquisition brought forth questions on self-incrimination and due process of law, when heretics spoke out against the church. They were tortured into admitting to crimes they may or may not have committed. The framers looked to the Inquisition in order to ensure that all people accused of a crime were given their due process rights, as well as protection from self-incrimination.
In the 15th and 16th centuries in England, people could not be tortured for confessing to crimes they were accused of. English citizens eventually stood up against this injustice and claimed that they had a God-given right to not testify under such circumstances. This protest of the people became the baseline for what became the right against self-incrimination. The First Congress drew upon this central principle by sanctifying it as the Fifth Amendment's self-incrimination clause.
The Fourth Amendment ought to apply to government agencies in order to maintain the security and liberties of the people, but it should not apply to commercial enterprises. The provisions in the Fourth Amendment were implemented to protect people from government, not commercial enterprises. As seen in the NSA scandal, agents like Edward Snowden are operating outside the parameters of the federal government. Because the mission of the NSA is to secure information for national security intelligence, they were bound by the restrictions of the Fourth Amendment. In order to protect individuals from an overbearing government, private subcontractors must also fall under the Fourth Amendment and the rule of law. This can be related to the current investigation of the CIA's unlawful spying on the Senate.
However, commercial agencies acting on their own interests do not need to operate under these same restrictions. When internet giants monitor information from users, it doesn't necessarily mean that the companies are infringing upon your rights. In fact, they are often allowed to monitor their users through their terms and services agreements. The Fourth Amendment must be changed through legislation to protect individual government agencies. The complication of today is best summarized by Benjamin Franklin. Anyone who trades liberty for security deserves neither liberty nor security. Thank you.
358.
What's probable cause?
So probable cause is the reasoning behind searching someone's things, or if the police officer has suspicion, and probable cause, like in school, could be seen if they hear other students talking about what could possibly be in someone's locker, so authority or even the administration at the school could search it.
Probable cause is a higher level than reasonable suspicion. Reasonable suspicion could just be getting information obtained from someone saying, oh, I think they have drugs in their backpack. Whereas probable cause is actually seeing someone put drugs in their backpack, and then you can search that based off of the probable cause you've seen.
Is there a right to die?
I believe there should be a right to die. There are 3 states that have legal euthanasia, which is Vermont, Washington, and Oregon. They allow assisted suicide with 2 doctors' help. And the 2 doctors have to go through certain provisions to ensure that these people are, they have to say the same thing, that they don't have the mental capacity to die, or the mental capacity to live anymore, and then only those 2 doctors would be allowed to euthanize them.
I also agree with Carmen that should be a right to die, because in the Constitution there is a right to life, liberty, and property, and one could argue that the right to life is the choice to choose whether to live or to die, and how you live your life and how you choose maybe to end it as well.
Argue against Tommy? Did you argue against Tommy?
So I know I don't believe that there should be a right to die, because each person, it can be beneficial to the common good. So that we need every single person we can get to possibly help us in any time of need.
Should the Miranda rule be modified?
I think the Miranda rule, the way it is doesn't need to be modified, because with the Miranda rights, it doesn't necessarily need to be read to you while you're, like, at that same moment you're being arrested, but as long as it is part of your due process rights, and when you're taken into custody, you know your Miranda rights. But as a citizen, if you know the rights you have and the rights you don't have when you're taken into custody, the Miranda rights being read to you immediately isn't necessary.
Building off what Kelsey said, people don't understand when the Miranda rights are supposed to be written, so instead of changing how the Miranda rules are said, they should educate people on when they're supposed to be said to you, as opposed to changing the rules completely.
But should it be expanded to involve more of our 21st century stuff?
I think you could argue that the Miranda rights could possibly include something about things that could be like your cell phone that could be searched on you, or in the Worry the US case, the bag that is possibly being unlawfully searched. So things could be defined more in the Miranda rights, what can be searched by authority.
I think it's hard to determine how the Miranda rules can be changed until we determine in the 4th Amendment what papers and effects are. There is no clear definition of what your papers are, especially in our age. Is a paper your emails now? And what are your effects? Does it include your cell phone?
Is due process flexible in times of war? Sure should.
Yes, due process is flexible in times of war, because if there's someone that needs to go back onto duty on the field, and we have to wait for their trial to be done, we need it to be quick, fast, but very thorough at the same time. So they need to be able to protect the United States in a time of war.
How does the Patriot Act impact privacy rights?
The Patriot Act impacts privacy rights because it's more leaning towards suspicion than probable cause for people's things to be searched, if there is suspicion of terrorism. So it kind of goes more into privacy because there's less protection for the individual of their things being searched, or possible emails about threats being searched now with the Patriot Act.
Building off what Kelsey said, the Patriot Act has allowed for people to become incredibly more intrusive into what you do, such as the TSA. They do more thorough pat-downs of you now, so it becomes much more an issue of where the line in privacy is.
How has the NSA and Edward Snowden affected privacy rights?
With the NSA and Edward Snowden scandal, it is metadata collection has recently been taking place, but it wasn't until Snowden that it became this worldwide problem that people everywhere were well aware of. Like me personally, I had no idea about the metadata collection until Snowden put out this news about the metadata collection. So now it's calling into questions about exactly what companies are doing and what exactly they are looking into.
Not only that, but despite that what Snowden did was literally an act of treason, it brought forth, clearly as we can see, it brought forth this discussion on privacy. It brought it into light, and now people are discussing where our privacy issues are and how far the government can intrude on those.
Where was the act of treason?
What was the act of treason? Go.
It was when he leaked, because he worked for the government, he leaked private documents to the public entities like news organizations and press.
Treason was also seen when he leaked these private documents to other countries, as well as leaving the country to.
Sorry.
He worked for a contractor who contracted with the government. So he didn't actually work for the government per se, though he had security clearances. And what he leaked were classified documents.
What's metadata?
It's data on data.
Yeah, what does that mean?
That's what Mr. Mack told us to say.
Okay, so you need to be able to define that. You know, because there's an element of the technology here that is important to the story, I think. So make sure you know the timeline, you know the connection between Snowden and the government, what metadata is, how is it collected. Because again, if it's collected after you put